There's still much ado about the court judgment which ordered the removal of Section 84, subsection 12 from the Electoral Act. While some lawyers have condemned the judgment by Justice Evelyn Anyadike of the Federal High Court, Umuahia in Abia State, others are miffed by the speed of the hearing, the manner it was delivered, and the swiftness in which the Attorney General of the Federation and Minister of Justice, Abubakar Malami, announced his readiness to implement that order. Jide, you know, according to the script, that judgment came, and before you could say Jack Robinson, nobody is talking about appeal. Nobody is talking about the judgment getting to the apex court so that at least it can be a locus classicus. But then the Attorney General has jumped at it, and we know people, because of their seeming selfish interest, they are always doing this thing. When they are reluctant to implement something, you see it. But when they are very, very swift, you know that there's an ulterior motive attached to this thing.
First, when the DSS went into Sunday Igboho's home.
Yes.
Destroyed his cars, destroyed his property. All those cars that he had in his compound, they were destroyed. You can't imagine that security operatives will go to that length. Then went in and even killed people, dragging them on the floor, and they were captured by the CCTV. The case went to court. We lost the matter.
What's the judgment? Attorney
General has not been in a hurry to implement the judgment because they were told to pay millions. Now the Kano too also won a case recently. That's
his own lawful or abduction in Abia State.
Yes. The destruction of his father's house and all that, which caused him, according to him, to run away for his life and jump bail. We didn't see so much haste to implement that judgment. Now, in this case, you can even implement judgment. But my own concern is the judge. That court is not a final court. If it was the Supreme Court, and we've had cases decided by Supreme Court that have not up till now, as we are speaking, have not been implemented. Now, that case, that judge, that court is not a final court. So why the indecent haste? Oh, because the thing affects you directly, you want to contest? So that's the issue.
I want to remain in office.
The people, there are questions that people have asked. Who is the claimant in this matter? Who is the claimant? Because for the claimant to file this kind of action, it must be that the provisions of that act affect him
directly.
Yes.
That's a locus.
Otherwise, it will be meddlesome interloper, as the judges like to call them. We still do not know. You can't say, oh, this person is just an APC chieftain. You must define who he is. What is his relationship to the matter? Because that's how we can determine local standard. That was not done. Then, the National Assembly that enacted the law in the first place, you did not. You were supposed to join them in the matter. You were supposed to join INEC in the matter. You did not join them in this matter. So how do they then defend themselves? Because it's their action that you're going to challenge in court. You must give them the opportunity to defend themselves that, oh, we took this action. These were the reasons. Yes. You did not join them. Nigerians have hardly seen this kind of case.
And if you had gotten to the Court of Appeal, they might have seen this deficiency they are talking about.
Then, this same, by our law, it is not the right, the Attorney General has not got the power to delete any portion of the law. The power to delete and make law rests with the National Assembly. So where a judge makes that kind of pronouncement, except if this case is not appealed, that's the only way that they can get away with some of these funny things that we have seen. And we've seen lawyers saying, look, judiciary should not ruin our country now. Because people must, NGOs, people must find a way to sue so that at least we can see where this whole thing ends. Because there are so many things that just do not add up. We are not lawyers, but we know that where you are challenging this kind of matter, the people behind it all, you need to join them in the matter. They are interested parties in the matter.
GKB, Mr. President, while signing this law, had raised this section.
Yeah.
But the National Assembly, that is like the representative of the people, in the Senate, it was put into votes.
And they lost.
Yes. And some people went to court, which is between their rights and everything. But we don't, at the end of the day now, no how, if this thing is deleted, that means the effort of the National Assembly in putting that clause there.
No, we are starting a precedent that we cannot defend down the line. Because that means that any federal court anywhere can wake up tomorrow and say the entire 1999 Constitution is unconstitutional. And then the chief law officer of the country will now say, okay, based on the fact that one obscure court in one obscure corner have decided that the Constitution is unconstitutional, it's going to gazette it, and Nigeria will be in trouble. So that's why, like Gideon said, we need to come back to the track that we all know, how these things are done. If the person went to court as a locus to stand on, let us know. If not, join the people that are supposed to implement this. You did not. The chief law officer of the federation, the man the president said he cannot go against his advice, was so eager to implement the law, implement this particular ruling without referring back to the entire act. Again, that is funny.
I think by now they would have deleted.
Yeah, because the boss will say immoral.
I think by now they would have deleted that session.
Because it's funny.
The way he was talking,
This should stand.
That's Nigeria for you.
So one day somebody will wake up and remove the president simply because he does not like the way he dressed. It could be that bad. And they say they will use
all it
this
takes
law.
is for one court in one corner
One
of our country, you know.
Jide, let's look at even the spirit behind this law, saying that, oh, you cannot sit down as a government appointee and you want to run for an election, so that you would not use that office, the power of that office, the funds and you know whatever it's into, you know, that a level playing ground should come to be. That is the spirit behind.
That is they want a level playing field. Somebody wants to contest as governor in a state and wants to hold on to his current position. It is because he knows that that current position accords him some privileges that you and I don't have. And if you and I are contesting against him, we are already at a disadvantaged position. That is the fact. You have access to policemen, have access to DSS people who can then be used to harass people on election day and all that. People know that in Nigeria, they've got to grab an opportunity when it beckons. The moment you step out of the vortex of power, those opportunities evaporate. We were talking about our colleague that they used to send a jet to go and bring him so that they can do interview. The moment you are no longer working in that media environment, you call people, they will not even pick. Goodluck Jonathan said that some of the people that used to come and see him, the moment he lost the election, they all stayed away. Some of them, he will call them, they will not even pick. That is Nigeria for you. The moment they can see that, oh, you are no longer there, that's all.
They move on to the next question.
More light on this. I have a lawyer, you know, joining us. That's Libros Oshoma, my friend from Anegbete. So Libros, now we know, yes, that controversial section, that's section 84, subsection 12, the National Assembly did not do the bidding of Mr. President. Somebody went to court and the court actually, declared it unconstitutional. And at the end of the day, we are talking about the speed, in spite of the fact that we still have the Court of Appeal and the Supreme Court.
Yeah, thank you, Ayo. That judgment has created more controversy than answers. Because if you look at Section 66, Section 137, and Section 181, that the judge relied on to say that this area is already covered by the Constitution, and so those sections I cited, particularly subsection 1, paragraph F or G, as the case may be, talks about those employed in the service of the federation, in the public service of the federation or the state government, employed in the service of the federation. And the Court of Appeal has held in pretorial authorities that there is a distinction between employment in the service of the federation and public office. Like political appointments are public office. And so, if those Section 66, Section 137, and Section 181 talks about those employed in the service of the federation, is there not a lacuna that the National Assembly can cover to legislate on, to say, oh, look, since the Constitution does not cover public service, political appointments, so now there's a law in the Electoral Act that legislates to cover those employed or those of the people, politicians who hold political office. So, but if the interpretation of the judge is to cover everybody, both those employed and those that are politically appointed, what that means is that including those who are politically appointed must resign their office at least 1 month to the election. So that will create a bigger problem than even the problem that the interpretation is trying to solve. And that's why I said it will create more problems. And then, when you talk about the speed, one would have expected really that a matter that borders on the powers of the National Assembly, and that the National Assembly has recently rejected the amendment, one would have expected that for a robust argument from both sides, National Assembly ought to be a party in the matter. That also was not the case. Also, if you look at the case, the defendant, the supposed defendants reside at domicile in Abuja, Attorney General in Abuja, National Assembly in Abuja, INEC in Abuja, and then all the way to Umuahia. I didn't even know that there was a federal high court in Umuahia until last week. All the way to Umuahia, and the speed with which the matter was decided. And if you read the order, the court said after due consideration, was it that there was no argument from both sides, or there was no argument, or the application was ex parte, and there was and the court will use an ex parte application to give such a judgment? So these are the questions that are begging for answers, and that's why a lot of people are saying that the judiciary should not allow the politicians to use it to destroy our democracy.
Now let's look at even the matter of not joining INEC or even the National Assembly that enacted this act in the first place. Could this have been deliberate to not give a chance or to have fair hearing?
I think it is deliberate, because before I even answer that, let me quickly highlight an area. The court also went further to empower the Attorney General to delete the said section. You will ask yourself, is the Attorney General a lawmaker to be deleting sections from a law validly made and passed? If a court invalidates a section, that section stands invalidated. Whether it is in the books or not, the section starts invalidated by court. All lawyers simply do is to cite that authority that invalidates that section, asking a member of the executive to now cloak himself with the cloak of a lawmaker and begin to add and delete sections in a law book is undemocratic. And then now coming to the issue of who should be the parties in such a matter. First and foremost, even the applicant or the claimant or the plaintiff, as the case may be, they said Unduka, Chief Unduka, who is alleged to be a chieftain of AA. It has also not been shown that he is a political appointee that will be affected by that section. Which injury has he shown to suffer by that amendment? So the Attorney General has consistently voiced his opinion against that section, and a few days before then had said that they were studying it and they were going to take a decisive step. And all of a sudden, the Attorney General, the same man who is allegedly a party in a matter, who also had voiced his opinion on a matter, who is the chief law officer, the legal advisor to the president, is sued. It's like, what you have here is like both both parties are the same. So the Attorney General is just added to give us a disguise of, oh look, there's an opposition. And then swiftly, an order was granted, and swiftly in less than a day, the Attorney General had complied with the order. What that means, the pointer to the fact is that the National Assembly was intentionally not sued in that matter, so as not to delay whatever they wanted to do. They also know that INEC also, from what I read, had its own in the judgment. So if INEC also had been a party, INEC, even as an umpire, probably would have also made a representation, as regards the said offending section. And then the court will have a robust robust argument from both sides to decide one way or the other. But this attitude and the way and manner the whole issue was handled, smack of suspicion, grave suspicion, and I think the National Assembly should apply as a party in the matter and then find opportunity to either appeal, But it's unfortunate when you hear things like this and you ask yourself, where are we heading to?
Once this thing is appealed, and let's say the Attorney General has gone ahead to delete that part as empowered by the courts, what will happen ultimately? Because some people will be affected, some people are expected to be affected because INEC, they have their timetable now, and we know some people, they are really, really interested in running for political office, and at the same time they want to still sit down there to use their current power to actually influence the seats they want to take.
I think that's why I said the judgment of this court has created more problems to would-be contestants, in the election, rather than solve the problem for them. So what should ordinarily have happened? I do not think that the Attorney General should be so hasty in deleting the said section. The Attorney General, it is not his duty to delete a section from our law. The law should remain as it is, because once it is invalidated, it stands invalidated. And then allow the Court of Appeal to have a bite on it if truly there's an appeal on the matter. And then subsequently, the Supreme Court will decide one way or the other. And whether the section is retained or not, then that becomes the position of the law. But to go ahead and delete the said section only for a court, maybe tomorrow, to decide that no, Attorney General, you don't have such power, and the court is not, the section is not contrary to the provisions of section 66, 137, and 181, then it means that you now have to print another Electoral Act again that will contain that section. Why do we like wasting money when you can as well just sit down and leave, the whole thing as it is? I mean, because even when there's an appeal on it, I also know that definitely there will be an application for stay of execution pending appeal, or stay or an injunction pending appeal. So, all of this, I do not think it is proper for the Attorney General, because I saw his release, instructing and issuing a release that they were going to delete the said section, and they were going to issue directive to the federal government printer to delete the said section. I think that would be too hasty for the Attorney General to do. And we shouldn't, Nigerians, I love the fact that, you also have taken up this matter, and being a prime program that you have a lot of followers. I like the fact that the station are taking it up to educate the people on the need why this should not be allowed to stand. If indeed truly there is a conflict between that section 8412 and section 66, section 40, section 137, and section 181, then allow a robust argument on both sides. Like it happens in courts in Lagos sometimes. Even courts will invite amicus, that's friends of the court, to provide argument on a matter such as this, so that the court will be opportune, to have, and a large, argument from both parties and then friends of the court, so that the court, at the end of the day, further deepen our democratic jurisprudence. But to want to ambush certain persons because you want to protect certain interests, for me, I think the court should not be encouraged to indulge in such attitude and acts.
Okay, we have to leave it there. Thank you so much, Libros Oshoma, a legal practitioner, and shedding light into the Electoral Act, Section 84, subsection 12. Thank you. Babajide, we are still looking at JKB because anytime we want to act, for the best interests of the country, that we are meant to be doing things and something that is futuristic in approach, not for now. Our public office holder, they tend to be selfish when it comes to, taking some decision on behalf of the country. Somebody's eyeing to be a governor somewhere. Somebody's eyeing the seat of the president. This is all what this is about. One night senators sat down together and they said, look, Mr. President, we feel this is not right. But somebody went to court in Abia State and we have ourselves in this region. And the court not only even ruled again, the court actually gave the power to the Attorney General, according to Libros, to delete that session, which we feel is all right. So, DKB.
Well, it just goes to show that the oath of office that they took really meant nothing. And that's why I agree with those who believe that we should move away from the Quran and the Bible as instruments of oath taking. We should do something more natural, like Ogun,
something closer to us.
Something that we believe in. Maybe that will change the perception.
That's the person that if you believe in Ogun,
you're a black man, and you drive cars, and you enter plane, and then somebody is called God of Iron. You think twice before doing other stuff. But on a more serious note, this does not go well for our democracy. It shows that people will do anything to put themselves in power than anything to do for the general good. That to me is the danger that this particular judgment portends for our democracy.
So in 5-10 years now, somebody will be looking at it and say, look, this thing is not supposed to be, we'll be back to this thing, and we put in place this motion, and ultimately we might get it removed. But why don't you just do away with it now?
No, in my view, we should just follow what the law says. From some of the research that I've done and my conversations with lawyers, I think that the combined provision of the Constitution was referring to public servants. Section 318, subsection 1. Public servants and political appointees are not listed
under
that section 318, subsection 1 as public servants. Now, section 84, subsection 12 of the Electoral Act was referring to political appointees. Those political appointees were not, such political appointees were not among the people listed as public officers in section 318 of section 1. So it's like misinterpreting the Constitution to achieve an aim. Because look at it, these guys are talking about political appointees, political office holders, to make it clearer. Yes, but the people that the Constitution was talking about in that section 318 subsection 1 are not this category of people. They are not the political appointees. And the Electoral Act was clear. It was referring to political appointees. So you can't use this section to rule on that matter, because this section 318 of the Constitution was not talking about, did not capture political appointees amongst
public servants.
Yes. So well, at the end of the day, we have that judgment. It could be that if this matter had been taken before a judge in Abuja, it could leak. Because look, let's face it, other organs of government ought to have been joined in this matter. They were not joined. INEC not joined. The National Assembly not joined.
So the judgment was given, you know,
if this case, I can tell you, it's very predictable. If this case is appealed, even on the basis of lack of fair hearing, for not joining these parties, for not joining them, the case will be thrown away. We've seen that this is the kind of case that a judge will not only set it aside, the judge will tongue lash the person who gave the original judgment. We've seen some judges tongue lash Okona Bank. Yes. Over some matters that even we are laymen here, we discussed, we said we felt that something was wrong with the judgment. And on appeal, the judge was told that he erred in law and then schooled. So this is what we are likely to see. I just want this, I want to see this appealed so that the people who contrived to make this happen do not get away with it. Because clearly by not joining those people, you are looking for a fait accompli. And I don't think it's right.
And according to Barack Obama, when he came to Africa, that Africa should strive to build strong institutions rather than strong men. So we are not looking at strong institutions with this move.
No, we are looking at abuse of institutions.
Yes, and
by strong men.
Yeah, yes.
This, of course, is a lacuna by itself, because you're a product of the institution. You now want to overload the institution to fit into your own narrative, but nothing lasts forever. That's what I don't get about people who do stuff like this. Ultimately, something will give, either the person or the structure. Most of the time, it's the person that will give way for the institution to thrive. And all these attempts to bypass the structure don't always work in the long run. We were here for the Abacha years. We are here for the Abubakar years. We probably will be here for the post-Buhari years. Just that people will keep tampering with our constitution. The constitution is very resilient. I always get better for it.
Did your last final word on this?
Yeah, I just want to see politicians moderate their selfishness.
Yeah.
I want to see
moderate their selfishness.
I want to see the judiciary not allow itself to be used by politicians, because when you allow yourself to be used by politicians, you become the laughing stock. The Yorubas will say, the politicians, when they are relaxed and they are drinking their Louis the 100, they will be talking about how cheap the judiciary has become. So the judiciary must hold its head high and do its job creditably.
Okay. GKB, thank you for your contribution. And it's 24 hours after your birthday. You're taking us out.
It's 24 hours. I think that one has the lacuna is that is gone.
There is no such thing as a lacuna.
Thank you. Thank you. Amir said yesterday you don't want to spend that.
No, God will keep us till next year. Next year is
it's in the spirit of the times.
And that's our offering today. Join us tomorrow for another episode of the program. You can watch the repeat broadcast tonight at 11. And don't forget to join us every Sunday for Journalist Hangout on Sunday, 1:30 to 3:30 p.m. We're on YouTube, youtube.com/TVC News Nigeria. I'm Ayodele Uzubakun. Bye for now, and God bless Nigeria.